thank you for coming out to this virtual program this evening on wills, probate, and estate planning in 2021, which, as we know, there have been a lot of changes. And Kenneth Burkhammon is our presenter tonight, and he's going to help you navigate through all of that. Kenneth Burkhammon is an attorney in Edison, New Jersey. He is the chair of the ABA Probate and Estate Planning Law Committee of the American Bar Association Small Firm Division. You wrote this very complicated, Ken.
Yeah.
He is the author of the ABA book, Wills and Estate Administration.
And where's my and Melissa? Before. Where's my office? It's
Your office is on Woodbridge Avenue
in Edison, New Jersey.
Edison.
Okay, so
yes, you'll see it when you're driving through towards Woodbridge.
So just
welcome,
you're going to if people go in the chat, people can make questions in the chat, and we'll try to touch upon those later on. So
please type them into the chat. Thank you.
Very good. So, okay, I always I like to do the programs for the East Brunswick Library because I live nearby. My friends are nearby, and it's important that people think about planning and how to protect their own family, and let's see, not put off things until sometimes it's too late. And oftentimes people will say they might see me at the East Brunswick VFW or East Brunswick Elks or someplace. It goes, Kenny, why do I really need to have a will? I'm married. Doesn't everything go to my spouse? I goes, well, yes, but that's not really doing any planning because both of you aren't going to live forever. And the idea of doing planning is to cut down on expenses, to make things easier, and not to give your family more work to do down the road. So if someone doesn't have a will or their will was not properly signed or done right because someone tried to use some a cheap thing online, the whole process not only becomes more complicated but becomes more expensive. So someone doesn't have a will. Let's say their spouse has passed, they have kids. That means all the kids have to agree together on who's going to be the administrator of the estate. Everyone has to sign what's called a renunciation affidavit in front of a notary saying, okay, I don't want to be the administrator, but we're agreeing upon this one person to do it. And then it has to be filed with the county surrogate and paid. Well, hey, we found out during COVID you couldn't find a notary. The banks were closed, the library was closed, etc. It became more difficult. Also, if all the kids don't sign this renunciation affidavit, then a complaint order show cause has to be filed in the Superior Court of New Jersey, to have the court appoint someone as the administrator. So they're spending over $3,000, and hey, doing a $400, $500 will make things easier and less aggravated. There's also additional expenses if there is no will or it wasn't done properly, because a thing called a surety bond has to be taken out. It's kind of like an insurance policy that's paid each year by the administrator to a company, and some people don't qualify for the surety bond. So that's additional costs that a properly done will weighs. State law determines who gets your assets, not you. Nowadays, more and more people are saying, you know what? I'm not going to give it equally to all my kids or to my grandkids. Who's been in my life, who likes me. On the other hand, sometimes people say, who needs it more? One of my, I had a client. She goes, listen, I love all my kids equally. I love my kids. However, she said, my oldest daughter's married to Dr. Rosenberg, the plastic surgeon. They live in a $2 million house, and then their second house on LBI is also worth $2 million. She doesn't need the money. But the third daughter was married to the loser. The loser doesn't pay child support. She goes, that person needs more money more than the other one. So it's someone can plan ahead to decide what's going to happen. If someone doesn't have a will, the people that don't even like you would inherit. If younger people have some type of issues, sometimes we don't want them to get money outright. And if there's minor children, a stranger The judge at the courthouse determines who gets custody of the kids. If you have a will, that you can take care of that. And but more importantly, when there's no proper planning, it often causes fights, aggravation, and lawsuits within the family. So when loved ones are grieving, they shouldn't have to worry about one more thing on top of everything else when they're overwhelmed. Let's say, so the whole bottom line, I tell people, do it right. Think ahead of time. Who do you want to get your assets? Who don't you want to get your assets? Who's for people with minors? Who's not the best choice to raise grandchildren, children? But also beware of these online documents not prepared by an attorney. They all say valid in 50 states, etc. Well, the problem is, let's say, yes, we can do our own electrical work by watching a YouTube video. But if we don't do it right, bad things happen. Let's see. So, hire the best thing to do is hire a professional, do it right. Now, what's some of the big changes that have happened in the past year? Well, office is closed. The surrogate's office closed. Well, how do we learn how to function? And in a way, a lot of law offices became much more efficient. We used to insist that people take the time out of work, make an appointment, come into the office, fill out the interview form by hand. And nowadays, everything's done online. We email a questionnaire to people. We save it as either a Word document or they can just type on their email what who's executor 1, who's executor 2. It's emailed back, and boy, you know what? That's cut down on the spelling mistakes when we can't read people's handwriting. And people take the time now where they can think at home what they really want, as opposed to taking half a day off of work, driving to a law office, filling out a form in a reception area on the spot. So again, the whole idea is trying to make things as easy as possible for everyone. Now, once people fill it out, again, let's say they pay by credit card online. Some people still want to mail in a check. Okay, that's fine too. We'll put it through the mail slot, and then we prepare the documents and we email it to people. That way, if we finish the document at 4 o'clock, someone can print it out at 4:30. And we do tell people though to print it out rather than reading on home, because that you much more carefully read the stuff if it's printed as opposed to trying to read something on your iPhone. And that's why we tell people print it, staple it, read it, make sure that everyone's name is spelled right, look at it. But now, during when everything was closed during COVID, how were people signing documents? Well, interestingly, what was still open? The UPS stores. I mean, banks were closed, libraries were closed, UPS stores were allowed to be open. So people were able to, we have instructions on people going to the UPS store. They need to bring 2 witnesses. One witness to the will can be a spouse. The witness on the power of attorney should not be the spouse or the agent, but it can be anyone else. You bring a friend, you put your mask on, you bring your own pen, you sign. So we made things easier for people, and because people over time were put offers, and the sooner people get their planning done, the better. I mean, we got caught. We were very busy in March, April, and May, because hey, a lot of people didn't know if they were going to get germs and die the next week. So it kind of was a call to action for them to say, hey, listen, I need to get this done. Let's say, just like it's no one needs life insurance until someone passes. No one thinks they need documents until it's an emergency and they need documents. So let's talk about some of the things that's needed. Well, again, we now email, the attorneys email a questionnaire to everyone. Make it as easy as possible. So let's say the questionnaire, someone types in their name, their spouse name if they're married, who's going to be executor 1, who's going to be executor number 2. Now, Let's talk about executors for a minute. That's the person that carries out the terms in the will. So you never ever want to have joint executors. There's a reason why there's not two presidents of the United States at the same time, and there's not two captains of the ship. There got to be one captain. So, and some people says, well, I got two kids, I want them to be co. He goes, no, why make twice as much work? That means two people got to meet with this, fill out papers for the surrogate. Two people got to meet with the realtor to sign the contract for sale. Two people got to sign the realtor listing. Two people got to sign the addendum. Two people got to sign every single check. Why make things more difficult if you don't have to be? And the executor should be someone that, our rule of thumb is, can they drive to a bank? Can they walk inside? Can they walk up a flight of steps and do the stuff? Do they have access to a computer? We're not anti-old people. We're not anti-senior citizen. We try to be as practical as possible because, hey, if someone can't drive to the bank, how are they really going to do the job as the executor? If someone doesn't have access to a computer, nowadays, how are they going to access accounts and bank accounts? If there's no one else at all. Now, someone asked me the other day, I said, aside from my spouse, I don't have anyone here in the U.S. Like my relatives are all, are in China. And I said, well, do they speak English? Yes. I goes, well, there's no rule that says that the executor has to be a United States citizen. No rule that says they have to be in the U.S. I mean, it'd be better if it was someone here, but as long as if the idea is it's someone you trust. Now, people ask, will a bank or a trust company do it? He goes, well, they typically won't be your executor or your trustee unless you have a lot of money. And charities will not be your executor, even if you're leaving the estate to them. They typically say, we don't want to be involved. So it's typically a family member that you trust. And this is a reason why I tell people, hey, if you have an old will, look at it, because how do you know if that person is still able to do it or who you want? So prior to a few years, here's something that New Jersey did. They got rid of a tax. Let's see, about 5 years ago, everything over $675,000 was taxed. So we had to do sophisticated planning for most of our estates. After that, New Jersey eventually got rid of it. So now there's only a federal state tax on estates more than $11.7 million. And not too many people I know that live near Route 18 got $11.7 million. Maybe some of those people that have the big houses on Farrington Lake, but most of the people we know are not in that kind of tax bracket. We do ask on the interview form, and attorneys ask, okay, do you own any real estate in New Jersey? Where else? If you own real estate in another state, there has to be a process down the road called ancillary probate. Let's see, and what assets does someone have? And we don't ask for bank accounts. We don't even list any assets in the will. And someone says, why? He goes, well, because the will is applicable for when you pass, and unless you're making specific bequests, doesn't have to go into the will, because you don't know the day you're going to pass and what you own. For the same reason, we don't even need, unless someone has a question on who the kids are, who the children are. Said to a nice lady, she goes, you don't list my kids' names. I goes, is there any question that you have two daughters? She goes, no. I goes, well, I'll list them if you want them to, but we don't need to list them. Now, but let me tell you something for a second, okay? Let's see. There are certain assets that don't pass under the will. The will only takes care of assets that don't have a direct beneficiary. So certain assets pass by title. And a main example of that is if a house is owned husband and wife, its tenants by the entirety automatically goes to the surviving spouse. If a house is owned joint tenancy, let's say a parent and one of the kids, or let's say a boyfriend girlfriend buy a house together and they decide to make a joint tenancy go to the survivor, it goes to the survivor. The will cannot change something that passes by title. What's something else that passes by title? Bank accounts. Bank accounts that are payable upon death, POD. Bank accounts that are joint, tenancy with right of survivorship, go to the survivor. The will doesn't change that. Certain assets pass by contract. Examples of those are IRA, 401k. If there's a beneficiary, goes to that person. Life insurance goes to whoever's the beneficiary. Some annuities that have beneficiaries goes to them. Some pension plans have beneficiaries. So, again, the will can't change that. So, I also recommend that people get a printout of who their beneficiaries are on these, these bank accounts, for when, especially when your executor doesn't live with you. So therefore, it's in your will file, and it makes life easier for the executor to know, who's getting what. So then you want to list. Let's say, hey, who's getting your stuff? But importantly, also, if one of those beneficiaries passes, who gets their share? There always has to be a what if. If that person passes, who gets their share? Now, I mentioned the word specific bequest. What a specific bequest is you're specifically giving money to someone, or an object to someone. So sometimes a lady say, listen, I want my jewelry to go to my daughter, my granddaughter, because if my son is the executor, he'll bring it to Cash for Gold and say, what did he give me for this junk? Sometimes the men will say, listen, I got, antique firearms, or I wanted to go to one of my family members, that this particular person that has a license and sometimes can enjoy it. As far as collectibles, I tell people this: they're really not worth that much. It's only a collectible when you're spending money to buy it. Hummels and things like that. We used to think all these baseball cards and coins are worth a lot of money. No, they're not. And nowadays people aren't those kind of collectors, so they usually get sold anyway. Sometimes people leave a specific amount of money for a charity, for their temple, for their church, for their college. I left money to the University of Scranton cross country team because that's where I ran. I left some money to the St. Thomas Aquinas high school track team because I ran there, and they needed some money. That way, it made me feel good. I mean, not a ton of money, but something that they could say, listen, look what we found, some money. But it got to be in the four corners of the will. So on Mother's Day, if Mom said to everyone, in the backyard when they're having something to eat, I want all my jewelry to go to my granddaughter, not only does the executor not have to follow it, the executor can't follow it because it's not in the four corners of the will document. So got to be within the in the will. Now, sometimes people have what we call the reverse specific bequest. And that means I am leaving nothing to this person. We don't leave them a dollar. We don't put a reason because that's someone's right. You had a person at a program said, do I have to treat all my kids equally? He goes, yeah, you don't have to. And then she met me in the office. He goes, what's your concern? He goes, well, she goes, one of my kids, we don't hear from that much. I goes, okay, well, let me ask you a question. On Christmas, did he get a card or a call? No. On your birthday, did he get a card or a call? No. On Mother's Day, did he get a card or a call? No. I goes, well, why should you leave anything to the person that doesn't care if you're alive or not? And that's going to be the person that is sometimes the biggest troublemaker, the biggest mouth when someone passes. Sometimes people nowadays, instead of leaving money to the kids, they leave it to their grandkids. Because they'll say, listen, I'd rather have it go towards my grandkids, going to college down the road, as opposed to my son buying a boat. That's that investment. And again, sometimes within the will, we set up trust for children, grandchildren. So if there's minor kids and minor children, we have a clause that says they get some money when they're 22, 25, and 30. Sometimes even greater because someone has an addiction problem, gambling problem, drug problem, whatever. You don't know, and that's it's a difficult issue sometimes to address, but people should address that. You don't want to leave money to a 19-year-old that is going to go down to Seaside and get someone to buy them beer and rent a place and have wild parties, because also you got to protect them from their newfound friends. We've learned if two parents die without a will, that means that each of the kids gets their money the day they turn 18. And I'm sure every single kid in East Brunswick High School is going to know that when Danny Wong turns 18, he's getting $300,000. Hey, Danny's our new friend. Let's get Danny to get a car and drive us around and pay for the prom table, pay for this. So again, part of the call to action is trying to make it as easy as possible for family. Now, if there's minor children, someone's going to set forth, okay, guardians and trustee. The trustee holds the money and supports them and can use the money for health, education, maintenance, support, college, grad school. The guardian basically holds the kids. So we ask people, okay, let's say we know there's no best person to raise your kids as you, but who would you want to watch your kids if you couldn't come home for the next 2 weeks? Let's see, who don't you want to watch your kids? So that's easy. Now, if anyone's writing any notes, write this down. Self-proving will, self-proving will. There was a change in the law under the previously. Person signed, then two witnesses signed. But then you had to locate one of the two witnesses to sign an affidavit to say, yeah, I watched a person sign and that's my signature. Well, a lot of times you couldn't find those witnesses, or they would say, yeah, I want $500 to sign it, otherwise I'm not going to sign it. They'd extort money out of people. So there was a change in the law. We do what's called a self-proving will, where the person signs, two witnesses sign, the attorney and notary signs, then we will sign again with self-proven language. This way, if someone passes, the executor does not have to locate the witnesses or the attorney or notary. And I mentioned attorney or notary because what was happening during COVID. We'd prepare the documents, we'd send them out to people. It goes, okay, here's what you're going to do. You print it out, and then let's say you're going to call the UPS store, make an appointment because they were allowed to be open, and easy. So also you want to make sure that the will has a clause that says no bond is required. Otherwise, a bond has to be taken out. And I've seen these cheap online things that don't mention anything about self-proving wills, don't say no bond required, and it ends up costing a family much more money. So get the attorney to prepare your documents, get it signed. Don't put it off. I remember years ago. We got through this. Most of us got through this COVID crisis. What happened 19 years ago? Like, I had a friend of mine who was working in Morgan Stanley in the World Trade Center. Let's say the day after 9/11, my office gets a call, and it was my friend Oki. Oki leaves a message. He goes, "I think I should get my will done," because he got out of the building. I said, "Oh, I'm so glad you got out. Coming on Thursday." The guy goes, "Well, I'm kind of busy." Busy doing what? You don't have any building. You don't have any work to go to. Coming on Thursday, let's get the stuff done. So, what we talk about is a call to action, getting things done. Don't be a putter-offer. Mr. K had come in to see us, and he said, "I like to read up about some of this stuff." And I said, "Mr. K, you don't need you're a retired guy. You don't need to read up about this stuff. I went to law school. I go to continuing legal education programs all the time. I lecture for the state bar. I've written a book on it. You don't need to read. I've read for you. For most people, I tell them I know best what they need. Just like when I was having knee surgery, I didn't read anything at all about the knee procedure. I called Rutgers Track Coach. Hey, who's the best guy you got on knees? They gave me a guy at University of Orthopedics. I goes, "Okay, doctor, you've done this before." He goes, "Kenny, I could do this almost in my sleep." "Okay, please be awake for my surgery, but I know you can do it right. I don't want to know about a lot of the stuff. So what's some of the clauses that go into the will? Debts and taxes are paid. Distribution to spouse. Sometimes we set up, by the way, a trust for a spouse. It's common in second marriage situations. Sometimes, though, when there was an estate tax, we would do it. Also, though, sometimes we can set up a trust within the will where the money's going to the spouse or in the trust for that spouse, and they're protected from Medicaid. They're protected from creditors. They're protected from the second spouse. And people don't like to hear that. I goes, well, I'd say, listen, things happen. So if it's a lot of people don't like to think about that or do it, but that's what we typically do. Okay, we have distribution to children. Sometimes a trust for the children, a trust for beneficiaries who are under 21. Sometimes specific bequest. I mentioned there's a clause that says who's going to be executors, who's going to be trustee, who's going to be a guardian. No bond required, and then typically we also go into I mentioned always have a self-proving will. So that is what you need to know basically about will. Sometimes people goes, oh, I like to have I like to get a trust done, and my mother-in-law used to come and see. Ask me every other year, I want to get a trust done. I go ask her, were you watching Susie Orman on TV? She goes, oh, yes. And I goes, hey, Susie Orman is exactly right. If you live in Florida, California, and New York, where probate is very complicated and expensive, but probate in New Jersey basically costs about $150. We bring them the original will, death certificate, check for $150. Fill out a form. I send it to them. Then they send me papers. Because the surrogate's offices are still closed due to COVID. We sign in my office, and then they're good to go. So most people don't need a trust. There are a couple benefits to a trust. If there's a trust, people don't have a living trust. The day someone dies, the trustee can start acting. But, and here's the but part. Let's say you're not really saving any money with trusts. It's a trust because New Jersey did away with estate taxes. You're paying $3-4 grand a piece for a trust. Revocable trusts do not protect assets from nursing homes. They don't protect anyone from taxes because you still control it. It doesn't protect from creditors. Sometimes the trust salesmen say, well, the assets aren't public, but why do most people need to hide, who's getting stuff, unless they're giving the stuff to the Ku Klux Klan or crazy groups. And the assets are transferred out of your name. Now, so I tell people, hey, listen, if you really want to have this revocable trust, sure, we'll do it. But I believe in explaining the options to people. Now, some people want an irrevocable trust. An irrevocable trust means you're not owning the assets. Someone else is the trustee. But after 5 years, 60 months, then those assets are protected from Medicaid in the event someone goes into a nursing home. So that's one of the reasons why some people set up Medicaid trusts, irrevocable trusts. Now, the next thing we're going to talk about is powers of attorney, powers of attorney, powers of attorney. Let's see. The will takes care of your assets if you pass away. What a power of attorney does is, if you become disabled, you slip on ice and you break your leg, you're in the hospital, you're picking someone you trust to make sure that your bills are paid and anything that's done financially is done for you, someone you trust. So, with the power of attorney is effective either right away or only upon disability. So, with the power of attorney, you're giving the power to the person to be able to, sell real estate, do your banking, do anything you could do legally that you could do. So, If it's effective right away, that's called a durable power of attorney because it stays durable even if someone becomes disabled and incapacitated. A springing power of attorney only, that's section B, only takes effect if someone is disabled pursuant to the definition of disability by the state, and there's a doctor's certification to that effect. We had a client though, he says, Kenny, you're talking to me in legal terms, legal mumbo jumbo. He goes, I'm a carpenter. I don't understand that stuff. Explain to me in carpenter terms what it means. He goes, okay. Let's say, if it's effective right away, that means that your son, who you're giving the power to, your son can steal all your money right away. I told him that's the durable power of attorney. Let's say, if it's a springing power of attorney, that means your son got to get a note from a doctor before he steals your money. Knowing that, you trust your son. He goes, oh, I trust my son with my life. I go, well then, most people make it effective right away. I mean, you're typically picking someone who you trust. Now, importantly, I mentioned not the cheaping out or some of these cheap or free things you find online. The trouble is, a lot of banks and institutions were not recognizing the power of attorney. They weren't following the power of attorney. So New Jersey legislature came up with a statute that says, listen, if the bank does business in New Jersey and it makes reference to New Jersey statute, they got to follow it. If not, a complaint can be filed with the Department of Banking in Trenton. However, it has to make reference to the statute. The statute is Section 2 of PL 1991, C95, C46:2B-11. And I'm pretty sure those free, cheap things you find online aren't going to make reference to that New Jersey statute. And, now, with the power of attorney, you want to look at your power of attorney periodically and say, okay, are these people still good for me? A will is good forever. Your will, if it's done right, it's good 20 years from now, 30 years from now. Sometimes you have changes in who's going to be the executor, okay? But on the other hand, you want to make sure that your power of attorney, the person who you picked, can they still do the job? I mentioned, can they drive to the bank and walk in and do the work for you? So now, one of the things that we've also recommended recently, since COVID, is after the power of attorney is signed, it's a good idea to scan the document and email the document to yourself, your agents, your financial institutions, your bank, the people that you trust. Now, but a scanned will is as good as a scanned $20 bill. It's not. Only the original will can be admitted to probate. So make sure that Executor 1, Executor 2 know where your original and can get to it. It's no good having it in a bank safe deposit box, because what happened last April? You couldn't get into the bank. You couldn't get to the safe deposit box. So most people just buy a fireproof box, put it under the bed, and leave it there. So doing the power of attorney for a lot of people is more important than the will. Hey, if we pass away, state law says, okay, if I'm married, I got kids from the same relationship, so automatically go into my spouse. No big deal. However, let's say if someone fell down and broke their leg, slipped on ice, slipped on whatever, the spouse doesn't have any legal authority to do anything. Your kids don't have any legal authority to do anything. And we also revised our documents, our wills, to have a clause pursuant to the federal HIPAA law so that doctors can speak to that person. So, again, don't be a putter offer. Don't be a putter offer. We get, oftentimes we get a call like, I need to get power of attorney over mom, dad, or Uncle Joe. Well, unfortunately, you can't get power over anyone. They have to affirmatively give it to you. They have to give it to they have to talk to the attorney. They have to sign the documents. If they're not in a position to sign documents, then you have to go through an expensive and complicated guardianship proceeding to declare your loved one incapacitated. It used to be called incompetent. That was an ugly word, so they changed it to incapacitated. But for the most part, it is it's usually people that are not competent. So let's see. Don't put it off. Get your documents done. There's no reason why someone can't get their documents done. I mentioned someone calls our office. We email them a questionnaire. They type it up, and within a couple of days, it's done back. They're printing it out, and then we go. And I'm calling everyone all the time. I mean, I got that great hands-free thing on my Ford Escape. So I press the button on the steering wheel. And it says dial this, dial that. I'm talking to people all the time. So don't wait. It used to be people say, I don't want to get. It could snow out. I don't want to go outside. And then it's too hot. I don't want to go outside. Well, no one needs to go anywhere for us to do the documents. All right. Now, let's see. One thing though, I mentioned. It is a good idea to sign a new power of attorney every 5 years. Banks, institutions sometimes are giving people a hard time because they'd say, well, this thing is 8 years old. How do we know it's still good? So if someone if you move, have a different address, have a new one signed. If the person you picked, your child changes their name or moves, have a new one done. You're not spending thousands of dollars doing it, and you want to have it done. We're going to... And now, by the way, what I also say is that anyone who's nice enough to come and listen to our presentation, we instead of charging them the regular $200 consult fee, if they come and contact us and fill out our questionnaire, our will questionnaire within 30 days, we don't charge them the consultation fee. And listen, if someone fills out our form, I talk to them. If they don't want to go forward, that's their call. But again, planning is important. Don't put it off. The last main document I'm going to talk about is something that's called the Living Will, Advanced Directive for Healthcare, Medical Proxy, Medical Power of Attorney. So a lot of us remember the Terry Chavo case from 2005, before the Karen Ann Quinlan case. So think of someone's in a coma, irreversible condition. So you want to be able to give if you can't talk, that's you want to give instructions to hospitals and doctors that say, hey, listen, if something happens to me, let's say, for most people say, pull the plug. I don't want to be I don't want to be in a coma, feeding tubes where there's no hope for me ever to come out of it. And again, it's a document for your family, not for you, because you're the one that is ill. So I remember one time a doctor asked me, where the person did not have a living will, and not me as the attorney, but me as the agent. Okay, what should today be the day? Meaning, should we remove life support today and end the person's life that day? And I go, geez, doc, I feel bad. The right decision is for someone who's 92 years old that's never going to open their eyes again and walk the planet. But you hate to be the one to say, okay, let's turn off the switch. I couldn't even do it for my dog when my dog was on the last day. So the idea with the living will is you're giving instructions to these hospitals, doctors, etc. So there's a section, basically, it talks about fluids and nutritions withheld or provided. Probably 85% of people now say, listen, there's no hope for me. I don't want feeding tubes withheld. Now, don't be scared. It doesn't mean if you have a heart attack that they're just going to leave you on the floor of, ShopRite and not do anything. They're gonna resuscitate you, do the right things, but then it's down the road at the hospital. The next section deals with different types of medical treatment machines, things like that. Most people say, if there's no hope for me, then 99% of people says, I don't want to be hooked up to machines just to keep my body alive after my brain is dead. Now again, don't be scared. When they first had COVID, they had the ventilators and didn't know how to treat people, stuff like that. They're not saying you shouldn't be treated. It's where someone's in a persistent vegetative state and there's no hope for them. Now, similar to the will has executor 1, executor 2. Your power of attorney has agent 1, agent 2. Your living will has agent 1 and agent 2. And the reason why this agent is important is because, again, they're going to be the captain of the ship in case the doctor has questions on certain things. And say under the federal HIPAA law, it authorizes the doctors and the hospitals to speak to that person. And what we also found is that sometimes all of a sudden someone's in a hospital and one of the kids who wasn't involved, wasn't helping out, all of a sudden they barge into the room and they goes, okay, I'm in charge now and this is what we're going to do. And the answer is no. Let's say mom or dad did their living will and you're not in charge. I'm in charge or this person's in charge. But hospitals like the doctor, they like the idea someone's done this ahead of time. There's even a federal law. They got to ask you if you go into the hospital for a surgical procedure, do you have a living will? Now, also we have we added a clause into our living wills for organ donation, yes, organ donation, no, and I always recommend people do an organ donor. I mean, you're already gone. If your earthly body can save someone's life or make their life better, why would anyone say no? I asked a question. The NJ Sherry Network had a seminar, and they're the ones that handle organ donors in New Jersey. And I asked a question. I said, hey, by the way, what's the maximum age to be an organ donor? They said there is none. He goes, well, what's good on a 85-year-old guy? And they goes, skin and cornea. I go, wow, I never thought about that. I mean, hey, if I was burned in a fire, I'd rather have old person skin than the stuff that got burned off me. So once you have your living will done, it is a good idea that you have it scanned, emailed to yourself, emailed to your family, sent to your doctors. That way they have it. You know what? At least for my family, it's on everything that's emailed is on my phone, so it is there. I mentioned probate in New Jersey is not complicated. I'd say other states it is. New Jersey it's not. So we work with the executors when there's a will. We fill out the forms. We forward to the surrogate's office a copy, not the original, first of the will, death certificate, the surrogate sheet. They look at it, then they forward us the paperwork to be signed and notarized. Then we send in, because the surrogate's offices in almost every county are closed to the public, then we send in certified mail or UPS the number one will, the original death certificate, the check, and the signed notarized papers. And typically then within a week we get everything back. What are some of the jobs that we help the executor with? Obtain a tax ID, set up the estate account. We have to serve a notice of probate on the different beneficiaries. Most executors say, listen, they have a choice of either hiring the attorney on an hourly basis or having the attorney work on 5% of the estate. Most people said, hey, the more work I do, I don't need to give you 5%. Okay, that's fine. Once they've wrapped up in, we help them with the sale of the house, but the other things most people can do on their own. At the end, an informal accounting is prepared, and then there is a form that's to be prepared by the attorney, sent to all the beneficiaries that are getting money, called a release and refunding bond. They all sign it in front of a notary. We file that with the surrogate, and then the executor gives out the money. Not that complicated. I try to talk fast because we have a lot to cover. But what I'd like to do now, East Brunswick Library, you can hear me now, right? We were hoping, yes, we were hoping to have a financial planner speak